Greetings, my name is Victor and I'm an academic legal researcher, specialising in decisions of the United Kingdom Supreme Court. On April 16, 2025, the Supreme Court detonated the landmark judgment of 4 Women Scotland and the Scottish ministers. The background to this case is that in 2022, the Scottish Government issued guidance stating that for the purposes of the Equality Act, anyone with a gender recognition certificate is to be treated as legally the sex that it says of their certificate, not their biological sex. The lawfulness of this guidance was challenged by 4 Women Scotland, who brought the case all the way up to the Supreme Court. They argued that this rested on a misrepresentation of the Equality Act, and in fact, the Equality Act referred to only biological sex, regardless of whether someone has a gender recognition certificate or not. The Supreme Court, in their judgment, decided in favour of 4 Women Scotland. They agreed. They said that in the Equality Act, the words man, woman and sex refer to the biological definitions only and not to what they call certificated sex. Unsurprisingly, this landmark judgment sent media commentators, journalists, politicians and your aunt on Facebook into a frenzy of misrepresentation. As one of the funders of 4 Women Scotland, the organisation that brought this claim to the Supreme Court, she who must not be named has been gloating on the hell site known as X. On the one side, this is a great moment for women's rights, and on the other side, this is turning back the tide of trans liberation, which will directly lead to the deaths of trans people. And yet, if you ask either side to explain what the judgment means in practice, you'll either get something incoherent, flagrantly wrong, or a statement that we need to wait for guidance from the Equality and Human Rights Commission. So I am here to do what lawyers do best, complicate the seemingly simple and simplify the genuinely complex. More specifically, I wish to dispel the untruths that have entered the public discourse about this judgment. In 2020, the secret barrister published a book called Fake Law, in which he talks about all the ways that laws are misrepresented in public discourse. To quote, he says that there are distortions of legal cases and judgments, spun and reformed for mass consumption. They represent a phenomenon that is far from new, but which, in an age of when an errant headline can reach 1 million Twitter users in a single baited click, is becoming broader in scope, longer in reach, and exponentially more difficult to counter. He further goes on to say that law is inherently, and often unnecessarily, complex and alienating to non-legal audiences. The public discourse around 4 Women Scotland is precisely one of these situations. I wish to dispel, therefore, 2 misrepresentations of the truth about this case, one being the definition of sex for trans people legally, and the other, the use of single-sex spaces and what that means as a result of this judgment. The first huge misrepresentation about this case is the definition of principally womanhood. The case did categorically not say that trans women are not legally women. And yet, this is the headline that you will see all over the media. Kemi Badenoch, the Conservative Party leader, has been the primary villain in this misrepresentation. She has seized upon this judgment faster than a politician seizes on a free lunch. Take, for example, Prime Minister's questions last week.
Mr. Speaker, does the Prime Minister now accept that when he said that it was the law that trans women were women, he was wrong?
Speaker, let me be clear. I welcome the Supreme Court ruling on this issue. It brings clarity and it will give confidence to women and, of course, to service providers. The Equality and Human Rights Commission will now issue updated guidance, and it's important that that happens and that all service providers then act accordingly.
What's worse, perhaps, is Keir Starmer's response, completely conceding the point to Badenoch and demonstrating the backbone of a chocolate eclair left out in the sun. Badenoch writes in The Telegraph that women are women. We didn't need a court to tell us that. But here we are. It took a Supreme Court decision to confirm what we all know. A piece of paper cannot make a man a woman. And yet, this is really a misrepresentation of the law. Indeed, other members of the Labour government, such as Wes Streeting, Secretary of State for Health and Social Care, have had equally sappy responses. Wes Streeting has said that he doesn't think it was right to say previously that trans women are women, get over it. This response to me is baffling. All of it is so unequivocally untrue. Under the Gender Recognition Act 2004, if a person is issued with a gender recognition certificate under Section 9(1), they are, for all purposes, the sex that it says on their certificate, i.e., If a trans person gets a certificate that says they are a woman legally under the Gender Recognition Act. The Gender Recognition Act is still very much in force. It's still very much valid. It's not been overturned by the Supreme Court judgment. In fact, the Supreme Court could not overturn it even if they wanted to. Those in possession of a gender recognition certificate are legally the sex that it says on their certificate, and the decision in For Women Scotland did not change this at all. In paragraph 2 of the judgment, it states that it is not the role of the court to adjudicate on the arguments in the public domain on the meaning of gender or sex, nor is it to define the meaning of the word woman other than when it is used in the provisions of the Equality Act 2010. The principal question which the court addresses on this appeal is the meaning of the words which Parliament has used in the Equality Act in legislating to protect women and members of the trans community against discrimination. That's it. It does not affect the legal validity of gender recognition certificates, and it does not affect the legal validity of the Gender Recognition Act. So why is this even in dispute in the first place? Well, this is because of Section 9, subsection 3 of the Gender Recognition Act. And bear with me now. While subsection 1 states that a person is their certificated sex for all purposes, subsection 3 contains some exceptions. It says that any other provisions in the Gender Recognition Act can count as exceptions to this, and this includes things like sports, and it includes things like parental rights. So a person who is trans and they have a gender recognition certificate, if they are listed as someone's father on a birth certificate, that will not change as a result of this certificate. It further states there are exceptions if another enactment of Parliament allows for an exception, amount to an exception to this rule. The Supreme Court said yes, it does amount to an exception. So this means that for the purposes of anti-discrimination legislation, trans women are biologically men and trans men are biologically women. But that's it. For all other legal purposes, i.e. 90% of legal purposes, people are the sex that it says on their certificate. This includes marriage, it includes pensions, it includes passports, it includes other official documentation. For those purposes, a trans person is still their chosen gender. This is something the Supreme Court expressly recognizes in paragraphs 99 to 100. It says that given the diminished relevance of the GRA to the rights of transgender people, the appellant argues that the rule in section 9.1 is also largely spent. We do not accept that. Although many provisions of the GRA have been overtaken by other legislative developments, we consider that the Act continues to have relevance and importance in providing for legal recognition of the rights of transgender people. This recognition of their changed status has practical effects for individual rights and freedoms, including, for example, the context of marriage, pensions, retirement, and social security, but also in recognizing their personal autonomy and dignity and avoiding unacceptable discordance in their sense of identity as a transgender person living in their acquired gender. How's that as a victory for the truth, Kemi? Every single word that's come out of your mouth about this judgment has been absolutely incorrect. The second major misrepresentation about this judgment that I wish to dispel is the consequences for same-sex spaces and services. This is the politically charged part of it, really. One of the reasons it's been hailed as a victory by the people who support For Women Scotland is that it's been misrepresented that single-sex spaces have to be for biological sex only. Aqua Reindorf, one of the commissioners of the Equality and Human Rights Commission, wrote in the Times that a service or competitive sport can be designated as single-sex if it meets the conditions set out in the Equality Act. If that designation is made, then the service or sport must admit only people of one biological sex. Otherwise, it ceases to meet those single-sex conditions and must admit all members of the opposite sex. And just to be clear, the EHRC was involved in supporting trans people in this case. But she's got it wrong. Harriet Harman, who is a Labour politician involved in the creation of the Equality Act 2010, put on X that the Supreme Court ruling interprets the Equality Act, giving effect to our intention when drafting it. Single-sex spaces for women are important and can exclude trans women, but only where necessary. The ruling protects rights of women while also respecting the dignity of trans people. This has been met with contention by people who willfully want to misrepresent it. She's right, by the way. Sharon Davis, who's been a big advocate for single-sex spaces being biological only, responded that that's not what the law today and sex discrimination law says. Single-sex spaces have to be single biological sex. That was the whole point of the court case. But it was not the whole point of the court case. This case was prompted ultimately by a requirement of the Scottish Government to have boards of directors be 50% women. And the question was, did that 50% include trans women or not? They issued guidance saying that it did, and that guidance was challenged. The judgment was really nothing about single-sex spaces per se, or at least it was not prompted by a discussion of single-sex spaces. Another response to Harriet Harman was from Legal Feminist, or Loud Bonnet. They say that single-sex spaces for women must always exclude trans women, a subset of men, or they will not be single-sex. It's like peanut-free meals. You have to leave the peanuts out. It's really not that hard. Well, if it's really not that hard, then how come so many people are getting it wrong, including you, Legal Feminist? As another example, Sex Matters, who intervened in this case, promoting the rights of biological women to have single-sex spaces, they say this judgment has put it beyond doubt that the Equality Act requires that where single-sex services are provided, this is on the basis of biological sex. If you provide a single-sex or separate-sex service, or manage a relevant sport, association or charity, you should make it clear that it is for people of that sex only. This means that the rules exclude males, trans women, from the women's category, and females, trans men, from the men's. Again, this is totally baffling because it turns the Equality Act on its head. And really, this is the most concerning part of these misrepresentations that I want to address. How they have been used by political fraudsters to champion their own causes. This interpretation is absolutely incorrect. The Equality Act is a piece of anti-discrimination legislation. It makes it unlawful to discriminate against a person based on several characteristics. The ones relevant here are sex and gender reassignment. Section 28 states, a person, a service provider concerned with the provision of a service to the public or a section of the public must not discriminate against a person requiring the service by not providing the person with that service. Discrimination meaning discrimination based on one of the protected characteristics, such as sex or gender reassignment. However, there are some exceptions. Paragraph 26 of Schedule 3 says that a person does not contravene Section 29 so far as relating to sex discrimination by providing services for persons of each sex if a joint service for persons of both sexes will be less effective and the limited provision is a proportionate means of achieving a legitimate aim. So if you're providing a service for women only and you have a good reason to do so, this is not unlawful discrimination. The key thing is that it is an exception to the rule. It might include things like a maternity ward, a changing room, or a rape crisis centre. The exception means that it's not unlawful to exclude men from women's spaces if there's a good reason, and vice versa. But the provision is about when it's lawful to discriminate against them. It doesn't mean that you must discriminate against them. That's an entirely separate thing. Lord Sumption, a former justice of the Supreme Court, went on the BBC Radio 4 programme to discuss this. He said,
that is absolutely clear as you've explained it. You're allowed to have a toilet that is biological women only.
Yes, but that is not discriminating against trans people.
Does that mean women's toilet has to be barred from allowing trans women? Because that's what everyone's taken it to mean, isn't it? You're not allowed to let trans women in, but it's not saying you're allowed to have one that's biological women isn't the same as saying it's got to be biological.
That's women. Absolutely right, and it's the main point which I think has been misunderstood about this judgment. I think it's quite important to note that you are allowed to exclude trans women from these facilities, but you are not obliged to do it. So, for example, the authorities of a sport, such as women's boxing or women's football, are allowed to limit it to biological women. They won't be in breach of the discrimination rules of the Equalities Act. But the judgment doesn't mean that the sporting authorities have got to limit women's boxing or women's football to biological women.
And he's absolutely right. To conclude that the Equality Act would require discrimination is not only to defeat the point of the Equality Act, but it's frankly absurd. Imagine a situation, for example, where there is a shortage of doctors in a maternity ward. This maternity ward has been designated as female only, And in the maternity ward, there is a person with a pregnancy, and there are complications around that pregnancy that might lead to the death of the fetus. Due to a shortage of staff, there is nobody able to deal with this pregnant person apart from a trans woman who works in another ward but is nevertheless qualified to deliver pregnancies. And by the way, that trans woman would be legally a woman for the purposes of their employment if they were in possession of a gender recognition certificate. If it were mandatory to exclude biological men from female-only spaces, that doctor would be unable to go into the maternity ward and deal with the patient. I guess the baby should just die. Can't have a man in the ward otherwise. Of course, the Equality Act does not mandate exclusion. It only permits it in certain circumstances. There is no state-enforced segregation. That would be like a trans apartheid, where the state is enforcing segregation between different groups of people. What's more, the Equality Act states that one must have a good reason for excluding these people. Paragraph 28 of Schedule 3 says that you may exclude trans people from same-sex spaces if it is legitimate to do so and proportionate to achieving the aim. It's very much an exception rather than the rule. You absolutely cannot exclude trans people just because you're a bigot. There must be some legitimate reason for doing so. Oh, and by the way, this includes all trans people, not just those with a gender recognition certificate. The Equality Act does not define gender reassignment as requiring a gender recognition certificate. It says that a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. So to justify the exclusion of trans people from single-sex spaces, you must provide a legitimate reason for doing so, and this applies to trans people both with and without a gender recognition certificate. Black Belt Barrister, a popular legal commentator, has highlighted an area where it is crucial this is understood. He points to the Building Amendment Regulations 2024, amending the Building Regulations of 2010.
For example, as a bit of a segue, which again will help organisations, there are regulations that require, at least for new builds, that they have single-sex spaces. For example, single toilets, single changing rooms. And here, for example, it says single-sex toilet means toilet facilities which are intended for the exclusive use of the same sex and provide wash basins, hand-drying facilities, etc. This was absolutely clear, if ever it was, under Rishi Sunak's government, that these restaurants, shopping centres, buildings, offices, etc. should provide these single-sex spaces. And now it's been absolutely clarified that that refers to biological sex only.
Firstly, I despair at the use of the term crystal clear around this judgment because, first of all, it has not made it clearer, as all of these misrepresentations have demonstrated. And secondly, have you ever seen a crystal? To return to the example, this is an amendment to the Building Regulations 2010, entirely separate from the Equality Act. Now, what was air clear from this judgment is that it only applies to the Equality Act. It does not apply to any other piece of statutory instrument or legislation. It does not mean that every other enactment relating to single-sex spaces also refers to biological sex as the only definition. It just means that if a service provider wishes to exclude trans women from a certain space that is single-sex, they may do so, and this does not amount to unlawful discrimination, but they are not required to do so, and this includes toilets. It's worth noting further that the Equality Act makes a distinction between services and associations. Paragraph 1 of Schedule 3 provides that it's not unlawful to create an association which permits people with a certain characteristic only. This means that an organization that is LGBT or that is lesbian only, it is not unlawfully discriminating against people who are not lesbians by not allowing them into the association. Now, unlike single-sex services, which was the other exception, there is no exception to this. This is particularly important because of the way that sexual orientation is defined in the Equality Act. Sexual orientation means a person's sexual orientation towards persons of the same sex, the opposite sex, or of either sex. So sexual orientation is defined as an attraction to one or both sexes. As the Supreme Court states, accordingly, if a gender recognition certificate changes a person's sex for the purpose of the Equality Act, a women's only club or a club reserved for lesbians would have to admit trans women with a gender recognition certificate, legal females who are biologically male. And again, remember that term, legal females. It's explicitly stating that they are still legal females, women under the law. Now, the next part of this concerned me a little bit, and it's kind of where I thought this reveals the true intentions or true allegiance of the Supreme Court. It states that evidence referred to by the second interveners suggests that this is having a chilling effect on lesbians, who are no longer using lesbian-only spaces because of the presence of trans women. Now just imagine that this were a different protected characteristic, say race. Imagine we were talking about a white-only space. If it were a white-only organization that didn't want to allow in mixed-race people who were, under some definitions of the law, also white, the judgment to invert these terminologies could say, evidence referred to by the second interveners suggests that this is having a chilling effect on white people who are no longer using white spaces because of the presence of mixed-race people. This is an entirely problematic statement and reveals, amongst many other things in the judgment, that actually the court is kind of out of touch. Anyway, their key wording is would have to admit. On the biological sex interpretation, as above, they are not forced to admit people into their associations, but they may choose to do so. Additionally, you could always make an association which is for two protected characteristics. So you could have an association which is for lesbians and trans women who are attracted to females, right? There's nothing preventing that. To reiterate, the Equality Act does not compel people to discriminate against anyone else. It just allows them to do so in certain circumstances. One of the foundational principles of liberal democracy is freedom of association. We can choose who we want to associate with and who we can not associate with. Indeed, Article 11 of the Human Rights Act 1998 states that everyone has the right to freedom of peaceful assembly or to freedom of association with others. So, if you want to allow people in your house or in your restaurant, you can. If you don't want to allow them in your house, you don't have to. For the state to require you not to let people in your house is a clear violation of this human right. It's a clear violation of freedom of association. And it is categorically not true that this is what the Supreme Court judgment requires. It is not something that the Supreme Court would ever endorse, at least not without a careful consideration of the consequences. It is the business of a fascist state to tell people whom they cannot associate with. It's not the business of a liberal democracy. So to summarize, trans people with a gender recognition certificate are their legally chosen gender for 90% of all purposes. They may be excluded from single-sex services if there's a legitimate reason for excluding them, and it is proportionate to meet the aim. There is, however, no requirement to exclude them. Each service provider must decide whether they want to include trans people in their services and associations or not. But this must be a general rule, and it cannot be done on a person-by-person basis. It must be absolutely clear from the outset what the policy is. Now, I had intended to do a step-by-step breakdown of the judgment and point out where I think they got some things wrong or could have made a better interpretation of the law, but this could be another hour-long video, and I've already talked enough. For now, I think the most important thing is to dispel the misconceptions about this judgment and to introduce some truth into the public discourse. I advise you to remember two things. First of all, when you see an organization state that trans people are now banned from using their service or joining their association, that's a choice they've made. They don't have to, they're not required to under the law, so make up your mind about their decision in whichever way you want to. Don't trust any media headlines you've seen about this case without further investigation, and certainly don't trust the black mold that is infesting J.K. Rowling's brain. For now, I bid you farewell with the greatest benevolence, Victor Baskerville.